Well, good afternoon, everybody. My name is Mike Engelson. I'm the executive director of Wisconsin Lakes. We're the statewide nonprofit that works on lake conservation, restoration, and protection, and is the organization of lake organizations in the state of Wisconsin. Glad that you were all here with us on this, as we were saying, slightly chilly, but warmer than yesterday afternoon. I'm glad to be joined by our collaborators in this, River Network, Midwest Environmental Advocates, and the River Alliance of Wisconsin. Kudos to River Alliance for doing a lion's share of the organizing and getting the all the administrative pieces of this going. Not speaking necessarily today, but present is Bill Davis from the River Alliance, who will be doing some presenting at one of the next sessions. Today, we're going to be talking about how to use the Clean Water Act to protect and restore your local waters. This is one of three sort of entry-level presentations that we'll be putting on. You'll find out more about how to register for the other ones. It's the same way you register for this one, so you probably already know, but that'll be coming up later on. Before we get going, I did want to just give you a quick overview of how to participate. You should not be able to unmute yourself, but if you can, please don't, so that we keep the background noise at a minimum. You will be able to ask questions, though. There will be two ways to do that. You can type your question in the chat. That's pretty easy. Or you can raise your hand, which, if you're not familiar with Zoom, either probably at the bottom, maybe at the top of your screen, there should be a bar. Should be able to hover over. There will either be a raise your hand choice right in that bar, or it might be in one called reactions, but somewhere there should be a command that lets you raise a little digital hand, and then when the time comes for questions, we'll be able to call on you. We're going to try to save most of the questions for the end so that the presenters get through their talks before we open up the floor. And we'll get to as many questions as time allows. We are scheduled to end around 5:30. And just a reminder that this session is being recorded so that anything you say will be kept for posterity. So think about it before you open your mouth, potentially. And with that, I will stop my share and let April start hers. And while she does that, introduce you to our first presenter. April Engel is River Network's Advocacy Director. She's worked for over 25 years leading organizations, collaborating with partners to advance clean water policy, and supporting individuals and organizations who are working together to protect and strengthen their communities and the places they love. In her current role, April provides training, tools, and resources and facilitates peer-to-peer exchange on a number of water-related topics, including using the Clean Water Act to protect and restore the health of our waterways. A big Wisconsin welcome to April.
Thank you, Mike. Yeah, I want to first just start off by thanking all of you for joining us here today, and also give thanks and gratitude to the River Alliance of Wisconsin, Midwest Environmental Advocates, and Wisconsin Lakes for hosting this Clean Water Act learning series. So as Mike said, I'm April Engel, and I'm the Advocacy Director at River Network. And to begin today's webinar, I'm going to share an overview of the Clean Water Act with you. I'll share some of its key components and how those components work together to protect and restore our waterways. And like Mike said, if you have questions or need clarification as I'm going through this high-level overview, please feel free to put your questions in the chat, and Rob or I will try to answer those questions either between our two presentations or at the end during the Q&A session. So to begin, I just really want to quickly, for those of you who may not be familiar with River Network, we've been around for over 30 years, and during that time, we have fulfilled a niche to connect and strengthen the network of water, justice, and river advocates who work for water at the community, local, state, and regional levels all across the country. And we focus our work in three results areas. So that's safe, affordable drinking water, healthy, resilient rivers and waters, and climate resilient communities. And we support these goals through online, virtual, and in-person learning opportunities and trainings like this, through the development of resources and tools, through convening peer-to-peer learning opportunities, providing one-on-one technical assistance and facilitation, and through our own advocacy. And also we organize a national conference called River Rally. And at the center of all of this is a focus on advancing equity, diversity, and inclusion and justice. So to get us started today, and before we start jumping into talking about the Clean Water Act, I'd love the opportunity to get to know all of you a bit more. So in the chat, I want to invite you to please share your name and the organization or community or river, lake, or watershed that brought you to this webinar today. I'd also invite you in the chat to share impacts of water pollution that you're seeing in your community or watershed, or on the lake that you're on a lake or a waterway that you particularly enjoy or love. And in the chat, I also invite you to share some of the sources of pollution that may be impacting your community or waterway. So I'll give everybody just a minute or so to think about these 3 questions on the screen. Put them in the chat, and then I'd love to just see what brought everybody to the webinar today.
April, if I may, I'll give folks in attendance an incentive besides just letting us know there. When I get to my part, I'm actually going to pull up a couple of databases and probably focus on one of the communities identified in the chat. So I see one entry so far, but encourage you the rest to do so.
Awesome. That'll be great for us to be able to get some real world look at some of the waterways that folks are caring about in their communities or in their watersheds. All right. So I'm seeing that we are starting to get some answers in the chat. Welcome to Dave and Tom, and Dan, Pat, and Christine. It's great to see you all here today. Some of the issues that are coming up in the chat include PFAS and ag runoff. So all of these issues, or both of these issues, and likely others that you all of you who are on the call today, as well as some of the ones that you see on the screen, are issues that are impacting waterways all across the country. And the Clean Water Act can be helpful to us as we think about these issues, what our options are to address those issues. So to begin, what I'll share with you today comes from the Clean Water Act Owner's Manual. It is one of River Network's most long-standing resources. It was first released in 1999, and a second edition was released all the way back in 2005. Mike is going to put a link to the manual in the chat so you can reference it as I go through my presentation. And also, if you want to bookmark it, that would be great too, because we hope you'll find that this manual is useful to you on into the future. And the manual is a how-to guide similar to other manuals that we have in our lives for how we can use the Clean Water Act to protect and improve the waters in our communities. So over the 20+ years since the manual was published, thousands of people have used it to apply the Clean Water Act to problems they're facing in their communities and watersheds. And it's also been used to train over 12,000 water leaders throughout the U.S. on how to use the Clean Water Act and how to use it to ensure that our waters are clean and safe, and how we can use it to track, influence, and change the way that the Clean Water Act is implemented at the federal, state, and the local levels. We also recently launched a new online self-paced training series that's based on the Clean Water Act Owner's Manual. So Mike's also going to put a link to the training in the chat. And it's a 9-part series where you can learn the ins and outs of the Clean Water Act, understand each of the Act's programs, and also the ways you can use the tools of the Act, as well as your local knowledge to advocate for the streams and rivers in your community. So if you find that you're interested in learning more after today's workshop, or you want to share what you learned with a friend or colleague, this would be a great place to start as well. So to start today's to start this overview of the Clean Water Act, I wanted to just give you a quick introduction to the different components. So in the chat, Mike's going to also put in a link to this graphic in case you want to refer back to it. We're going to be coming back to this graphic all throughout this overview that I'm going to give. So, okay, so let's get started by looking at the Clean Water Act vision and goals, which sets the stage for everything that the Clean Water Act entails. And if you want to follow along in the manual as I go along in the overview, you'll see that we note the relevant pages in the manual on the bottom right of the slides as well. So the primary vision of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. It's important to remember that the Act is not just about identifying and correcting problems. It's also about identifying good water quality where it exists and protecting that good water quality. The Clean Water Act also sets interim goals and national policies to guide us on the path towards this lofty vision. The first goal is to eliminate the discharge of pollutants into the navigable waters by 1985. And the second goal was to achieve water quality, which provides for the protection and propagation of fish, shellfish, and wildlife, and provides for recreation in and on the water by 1983. So you may have heard that the Clean Water Act says our water should be fishable and swimmable and drinkable. That comes from this second interim goal. So fishable is shorthand for the quality necessary to support the protection and propagation of fish, shellfish, and wildlife, and swimmable is shorthand for the quality necessary to support safe recreation in and on the water, and includes all types of water-based recreation. And while we have definitely missed these deadlines, and that can be really discouraging, it also still serves as motivation for us to keep working towards this vision and goal that was established. It's also important to understand which waters are protected by the Clean Water Act. The nation's waters, or waters of the United States, which is often referred to by its acronym WPDES, are legally required to be restored and protected by the Clean Water Act. But how does the Act define what a water of the U.S. is? So answering this question has been a moving target since the early 2000s, when U.S. Supreme Court rulings, several of them, as well as several subsequent agency rulemakings, and then repeals of those rules all came into play. And then a Supreme Court decision back in May of last year dealt a catastrophic blow to the definition of waters of the U.S., which has now had to be codified into a revised rule by the EPA and the Army Corps of Engineers. We'll put a link in the chat to some resources where you can learn more about this decision and how wetlands have been impacted by the decision. And we're also going to discuss this issue more in depth during the next webinar in February. But for now, what's most important to know is that this definition matters because it defines which waters are protected by the Clean Water Act. The next component that is I'm going to give a brief overview of when it comes to the Clean Water Act are water quality standards. And these are the foundation of so many of the other programs in the Clean Water Act. You'll remember that one of the Clean Water Act's interim goals to achieve water quality that provides for the protection and propagation of fish, shellfish, and wildlife, and provides for recreation in and on the water by 1983. This led to the development of the Water Quality Standards Program. And water quality standards are just that. They are the measurable standards that each water body, down to particular reaches called segments, are supposed to meet so that they are fishable, swimmable, and drinkable. And the responsibility of this program rests primarily at the state and tribal level, but the Federal Environmental Protection Agency also has oversight to ensure that the standards meet the requirements of the Clean Water Act. And water quality standards have three components that you'll see here on this graphic. They identify how waters are used, and these are called designated uses. They also establish criteria to protect those uses. These are called water quality criteria, and they require waters to be protected from degradation, and this is called the anti-degradation policy. And the Clean Water Act also requires each state and tribe that has the authority to administer water quality standards to hold regular public hearings on the adequacy of its water quality standards. This process is called a triennial review, and it must be held at least every 3 years. To meet the goal of eliminating discharges of pollution and to meet water quality standards, the Clean Water Act also regulates the discharge of pollutants into our waterways. This is the piece of the Clean Water Act that we're mainly going to focus on today. So to regulate the discharge of pollutants, the Clean Water Act created the National Pollutant Discharge Elimination System, or NPDES permit program, and it was established to prohibit any dumping of pollution into water bodies from pipes, ditches, or what's referred to as discrete conveyances, unless that pollution is permitted. The Clean Water Act authorized the EPA to delegate the responsibility for the pollution discharge permits to states, tribes, and territories. So EPA has delegated the authority to administer the permits in most states. There are 3 that it has not. But EPA writes the permits on almost all tribal lands, as well as a few states, the District of Columbia, and U.S. territories. And the EPA retains oversight and veto authority over the permits that are issued by the state. The NPDES permits are effective for 5 years, and they are to be reviewed, adjusted as necessary, and renewed at least every 5 years. However, many states are far behind in this process, and it is common for permits to be administratively extended for several years beyond their expiration without sufficient review if they're protecting water quality standards. As depicted on the graphic to the right, these permits can be issued for individual facilities or activities under individual permits, and they can be issued for categories of activities under what's called a general permit. Individual permits are common for large sewage treatment plant discharges, large industrial wastewater discharges, and stormwater discharges from large municipalities. And public review and comment are required for every individual permit. General permits, on the other hand, are developed for numerous categories of activities within a political or geographic boundary that share similar operations and discharges, require similar permits or operating conditions, and require similar monitoring. And general permits are common for stormwater discharges, concentrated animal feeding operations, and many types of industrial wastewater discharges. The public is allowed to review and comment on general permits, but only every 5 years as the broad permit is developed, not when each activity is granted permission to discharge pollution under the general permit, which is different from an individual permit where each permit must have a public comment opportunity as they're issued or reissued. Most states have a process for the public to request that a facility or activity be subject, though, to an individual permit in cases where the pollution is causing or contributing to a violation of water quality standards. And some basic information in the permit that you can find includes pollutants and their volume, typically the maximum that is discharged, and the limits within which they can be discharged. Also, the location of the discharge, where the pollution is discharged into a water body, the expiration of the permit, when the permit will be up for renewal, which can also tell you if it's already expired or has been administratively extended. And then finally, well, not finally, but also some key information that you can find is information on the waters that are receiving the pollution. So that could include things like the water quality standards for those water bodies, if there are any impairments to the water quality standards, and if there is sufficient stream flow to assimilate that pollution. And next, moving on to other types of regulated activities to meet the goal of eliminating discharges of pollution and to meet water quality standards. The Clean Water Act also regulates dredging and filling of wetlands and waterways. And this program was set up to address pollution from activities that involve dredging in or filling in of waterways by requiring permits for those activities. Those permits are known as Section 404 permits. And that refers to the section of the Clean Water Act that requires them. And these permits are required of anyone who proposes an activity that would result in point source discharge of dredged or fill material such as dirt and mud and pollutants that are attached to them into a water of the U.S. And Section 404 permits are commonly required for things like land development activity, so construction of shopping centers or large housing developments, bridge building and maintenance, dam building and maintenance, and new oil and gas infrastructure that is being built on or in or near rivers, lakes, and wetlands. And we're going to focus on this program during the next webinar on February 14th. So if you want to learn more about that one, if you haven't already registered, we hope you will. Next, in order to ensure that federal activities won't violate the Clean Water Act, Section 401 also gives states and some tribes, as well as interstate agencies and EPA at times, the authority to veto or place conditions on activities that require a federal license or permit that might result in discharge of pollution. So through Section 401, states and tribes have the authority to review federal permits and licenses that are issued by federal agencies to ensure that they're in compliance with water quality standards and the other state or tribal water quality requirements. So some examples of federal permits and licenses that require Section 401 review include pollution discharge permits that might be written by EPA, dredge and fill 404 permits that are written by the U.S. Army Corps of Engineers, and licenses and permits that are issued by the Federal Energy Regulatory Commission for things like dam building or for oil and gas infrastructure. Next, connecting back to the Clean Water Act vision, in order to restore the integrity of the nation's waters, we also have to assess and report on the quality of waters to know if they're meeting water quality standards, that designated uses are being supported, and that water quality criteria are being met, and that waters aren't being degraded. So every state is required to determine the status of all the waters in their jurisdiction and compile all existing and readily available water quality data and information into a biennial report that's called an integrated report that's due to EPA every 2 years. And the report must also include the state's determination of whether all designated uses are being supported and a list that calls out which waters are not meeting these standards. And this list is called the Impaired Waters List, or the Section 303D list, after the section of the Act that requires it. Next, the Act also authorizes funding to assist government, non-governmental organizations, and businesses to take action to meet the goals of the Act. Two such programs are funds to address polluted runoff from non-point sources of pollution, which are often called 319 funds after the part of the Act that authorizes these funds, and improvements to clean water infrastructure through the Clean Water State Revolving Fund, or the Clean Water SRF for short. Section 319 also requires states and tribes to prepare assessments of their non-point source pollution problems, to develop management programs to address the problems identified in their assessments, and create a grant program to fund state and tribal programs for non-point source assessment and control. The Section 319 funds for states must be evenly split between funding the state's non-point source management program activities that include the planning, assessment, and management and statewide projects and watershed-based projects. The second step required to meet the Act's goal to restore unhealthy waters is to identify a pollutant cap and develop a water quality restoration plan to address impairments. This is what we will focus on in the third webinar on March 21st, so we hope you'll sign up for that one as well. The term total maximum daily load, or TMDL, has come to represent both a pollutant cap and a restoration plan to get waters back to meeting water quality standards. The pollutant cap is a calculation of the maximum amount of a pollutant that a water body can receive and still safely meet water quality standards. The restoration plan describes how to achieve that cap by identifying pollution sources and the amount each source needs to be reduced by. However, surprisingly, implementation of OTMDL is not required by the Clean Water Act, but it is often a common component of the TMDL process and often involves changes to permits for point sources and best management practices for non-point sources of pollution. Finally, the Clean Water Act prioritizes public participation in its first pages, and this is where all of you come in. Every program provides opportunities for public notice, input, or review though they differ across the different programs. Most Clean Water Act programs have a mechanism to challenge final outcomes if unlawful through administrative appeal or court procedures. The Clean Water Act Section 505 is devoted to a citizen suit provision that's similar to several other federal laws. And this provision allows individuals or organizations who may be adversely affected by certain action or inaction to file a lawsuit to enforce the Clean Water Act. All of the public input and review opportunities are a vital part of successful implementation of the Clean Water Act. And without it, frankly, the Act just can't work. And that's why you all are such an important part of successful Clean Water Act implementation. So with that, I'm going to turn it over to Rob next to dive into Wisconsin Department of Natural Resources implementation of the Clean Water Act, Section 404 surface water pollution permitting program, and how you can participate in the process. But before I do, Mike, are there any questions in the chat from the overview that Rob or I can help answer or clarify?
Nothing that I have seen so far. I did ask people if they had any questions to go ahead and type them into the chat, but it doesn't look like anything's coming up. If you're like me and a slow typist and wouldn't have time, that's okay. We'll catch you at the end. So we'll turn things over then to Rob Lee, who is a staff attorney for Midwest Environmental Advocates. Rob earned a political science degree from the University of Arkansas, a law degree from University of Notre Dame. He did a lot of great things during law school. In his free time, he likes to immerse himself in the great outdoors. Thankful to be doing anything outside. Rob particularly enjoys hiking, fly fishing, and photography. I'm assuming that does not count on days when it is both cold, and he can talk about permitting, Clean Water Act permitting in Wisconsin. So we'll turn things over to Rob Lee.
Thanks, Mike, for that introduction, and April for your overview of just the Clean Water Act generally and signaling the different issues that we'll not only address here today, but also in our 2 subsequent webinars, which I certainly recommend that our participants today register for and attend as well. Those will be extremely informative. As Mike mentioned and April mentioned, my name is Rob Lee, and I'm a staff attorney at Midwest Environmental Advocates. We're located in Madison, Wisconsin. We're a nonprofit law center that combines the power of law with the resolve of communities facing environmental injustice to secure and protect the rights of all people to healthy water, land, and air. I will say that MEA specializes in Clean Water Act implementation here in Wisconsin and has for almost a quarter century. And, the fact that our budget comes from private donations and grants rather than, for example, like government funds means that we have the freedom to pursue environmental protection wherever it leads, even if it means going right after the regulators and holding government's feet to the fires, right? To do more to protect the environment or hold polluters accountable. So I want to encourage you, if you want to find out more about MEA, to visit our website. You can see the URL though at the bottom of this slide, and and you could go there, and you can also sign up for our newsletter and podcast. I will also say that I'm going to go through some of these slides a little bit quick. I want to address some of the issues that were raised in the chat, like PFAS and stuff like that. And so I'll say one that I'll make these slides available to you for reference, but also just flag that MEA operates an intake program. So if you have a specific question about a WPDES permit or with the WPDES program, I want you to consider me and MEA more broadly as a resource. If you have questions, please reach out. We may not be able to answer every question or take every potential case to the Supreme Court, but we certainly can get you pointed in the right direction. So as April indicated, though, what I'm going to talk about is the Clean Water Act NPDES, or the Section 404 permitting, what that program looks like here in Wisconsin. And I'll go through the development of water quality standards, talk about the elements of a permit, some regulated substances, stepped enforcement, all kinds of issues. But I did see a potential or a particular interest in PFAS regulations identified in the chat, so I'll try to incorporate that as we go along. Okay, like I said, I'm just going to jump in here, and I may go a little fast on some of this. Some of it may retread things that April already covered. So slide number one, here's just saying here in Wisconsin, instead of the NPDES program, we have the WPDES program, right? It's not the National Pollutant Discharge Elimination System. We got very clever and called it the Wisconsin Pollutant Discharge Elimination System. So whenever you're looking for this in a Wisconsin-specific context, you want to look for WPDES, not NPDES. Like the NPDES program, it prohibits discharges of pollutants, but unlike the NPDES program, which is tied solely to waters of the United States, our state WPDES program goes further than that, and it applies to waters of the state. So no discharges of pollutants to waters of the state without a permit, and waters of the state here in Wisconsin is certainly defined much more broadly than waters of the United States has been at the federal level. And the reason we can get away with that here is because while entities that have been delegated Clean Water Act authority must be as stringent as the Clean Water Act, they definitely can be more stringent in most instances. Okay, so what are the differences in the definition of waters of the state, right? I think the big ones in this definition here that you'll see are groundwater, right? This is something that is not regulated through the national or the NPDES program, the national program there. Artificial waterways, I think, are a little bit interesting too. I think there's more of a question under WPDES here, whereas they're absolutely under waters of the state. The other thing, and we'll absolutely talk more about WPDES in the wetlands context, but I will say that waters of the state and wetlands are actually independently defined here in Wisconsin and not necessarily tied to one another. But, and just as a flag later on, particularly for PFAS, right, the incorporation of groundwater into waters of the state can have important ramifications here when it comes to regulating discharges to these water bodies. The next thing I'll get in here, this stuff has already mostly been covered, right? When it can be renewed, all of those things, the protecting through water quality standards approved by EPA, even triennial review. But I will say there is a public participation opportunity in triennial review. And if I'm not mistaken, that's up next year. So search on Google, DNR triennial review, and you too can participate there. The biggest thing here is just an anecdote about administrative extensions. Certainly they can be extended just because there's a permit backlog and DNR doesn't have enough time to get to them. They can also be extended if the reissued permit is currently subject to litigation, right, through a contested case hearing or beyond that. The currently existing permit will be extended there as well. April mentioned a few years. The longest permit administrative extension I've seen is actually 16 years, which is absolutely unacceptable in my opinion, but it nevertheless was the case. So in the spirit of moving quick, I'm going to move on. Next slide here, elements of a permit. Now, certainly April overviewed different like general things that you can expect to find in a permit. This here gets a little bit more specific. I'll start with water quality based effluent limitations here on the middle left part of the screen, which is the principal way that water quality standards are implemented, right? When April said the concentrations at which a substance can be discharged, for the most part, we're talking about water quality based effluent limitations or WIC bells, if you will. WIC bells are functionally how you translate the water quality standard, which is what the quality of the receiving water must be overall versus what the concentration of a particular pollutant can be in the wastewater being discharged, right? To ensure that that discharge then doesn't cause or contribute to an exceedance of a water quality standard in the receiving water body there. Now, kind of going back to the goals of the Clean Water Act, right? It's not necessarily just to meet water quality standards that can provide for certain basic uses, but to fully restore and maintain the integrity of our water body. And that can't be viewed just with like in respect to an individual permittee, right? You have to consider multiple permittees on along a water body and the fact that there may be new or increased discharges in the future. So we have to not only make sure that the water quality standard isn't exceeded, but have a buffer. And so in certain instances, even if the water quality, the WIC bell would be one effluent limitation, if there's technology that's feasible, right? Economically practicable, like and efficient and all of those things, we can also have more stringent effluent limitations based on what technology can do, right? It's not that you just can meet the bare minimum. You need to be doing everything to eliminate the discharge of all pollutants to waters of the United States by extension, right? We're supposed to meet that in 1985. That's the year before I was born, just so you know. I'm 37 years old, right? And we're nowhere even close. Other things you'll see, right? You may see special conditions with additional monitoring or best management practice, compliance schedules. I'll talk about that more later. DMRs, right? Or designated monitoring reports are something really important. These are the monitoring and sampling information that needs to be submitted to regulators to ensure that they are in compliance with their permits. You'll also see just standard clause, right? If there's a change in your discharge or the factual scenario on the ground, or you misrepresented the nature of your discharge, DNR can either reopen that permit, right, and change the terms and conditions. It could inspect to see what's going on. It can outright revoke your right to discharge underneath a permit. So these are different elements that you'll find in a permit. And just an overview there, obviously it's way more complicated than that, but things you should be looking for in that. Okay. I just wanted to give you an idea of the types of substances that are regulated through water quality standards. This first bullet point here, phosphorus, dissolved oxygen, pH, bacteria, and temperature. right? These are interesting. Really only bacteria and phosphorus, if I'm correct, is considered from like a concentration type point of view. Obviously, temperature and pH are slightly different. And even dissolved oxygen. But all of those things can certainly impact the different uses of a water body. In addition to that, there are a multitude of toxic substances that are regulated both for their acute, right? So if you ingest this now, you can expect these types of immediate impacts, or chronic, right? If you are ingesting this substance over time, we can also expect these types of adverse impacts based on that. Way too numerous to list. But here are some examples, right? Arsenic, mercury, copper, different metals there, other things like benzene, toluene. And in Wisconsin, not at the federal level, but in Wisconsin, since August 22, we do have surface water standards for PFOA and PFOS. The one thing I want to point out here, though, is in addition to this, since waters to the substances that are identified in the code specifically implementing the WPDES program, groundwater. Remember, I mentioned groundwater is part of waters of the state. We have a whole entire separate administrative code that imposes groundwater standards, which are incorporated as necessary into WPDES permits. But like I just mentioned, for PFAS, for example, we have surface water standards for PFOA and PFOS, but not groundwater standards. That debate is ongoing right now, and you should get involved in favor of these. But right now, we cannot protect discharges regulated through the WPDES program. We cannot protect groundwater from those. Not yet, anyway. And the hope is that we soon will be able to. But for other substances, we do have groundwater standards for, particularly when it comes to land spreading like biosolids and wastewater residuals. They absolutely have to be cognizant of those groundwater standards as well. That's not an issue in Wisconsin. I'm going to do a quick time check. Okay, it's only 4:44. Haven't been going too long. So I do want to just talk functionally a little bit more in depth about how water quality standards are developed, and then how you decide which one applies in a given situation, and then how you develop an effluent limitation, potentially, if it's a numeric criteria, or a different perhaps performance standard if it's a narrative criteria. But what April was getting at, these designated uses, in the first instance, we're looking at all the types of uses that any or all water bodies could conceivably be used for. As a bare minimum, they absolutely need to be fishable and swimmable, but those aren't all the only reasons that surface water can be used for, right? We use those as drinking water supplies as well, and we need to be cognizant of those particular water bodies that are also used for additional reasons, right? And DNR has to think about how each substance it regulates, or different pollutant, maybe, instead of a substance like temperature or pH like that, how each of those may impact each use, right? So what is the water quality standard necessary for PFOA, perhaps in a drinking water setting, right? What's that in a recreational setting where you may be swimming or wakeboarding or something like that, and maybe there's some dermal absorption, but there's also incidental ingestion by drinking water that gets in your mouth. What's the standard for that? What's the standard for impacts to fish and aquatic life, not only in their own right, but if those things were also consumed by humans, right? Do these substances bioaccumulate in those? And then broader, of course, just general wildlife as well, that itself may be consuming that water body, consuming other fish and aquatic life in that water body. So whether it's a toxic substance, whether it's temperature, taste, or odor, DNR is looking at the different ways that those pollutants could adversely impact those uses, and setting a standard for each one, right? Now, when you get to a specific water body type context, right? This is probably too in depth, so I'm just gonna skip past that. But whenever you get to a specific water quality context, right, then you figure out which of those need to apply based on what that receiving water's actual designated uses are, right? They all have to be swimmable and fishable, but beyond that, right? And those criteria for each pollutant, for each use, those are called water quality criteria, individually criterion, right? So then you just look at the receiving water body, you determine what its designated uses are, you establish what pollutants are going to be discharged, right, from the entity trying to get the permit. You establish which of those have the reasonable potential to contribute to the exceedance of a water quality standard. Then you go over and you figure out which water quality criteria is the most stringent, right? If the most stringent is protecting humans from drinking water, you pick that one. If the most stringent is the chronic toxic criteria for wildlife, like for mercury, which often is the case, you pick that one, right? So that ends up being your applicable water quality criterion. It's often expressed, as I indicate here, as a numeric threshold. Here's an example: copper, which is a toxic metal, which we find naturally occurring, but also in waste streams, is set at equal to or less than 12 milligrams per liter, right? So we can also, though, as I point out, have narrative standards that make sense for certain types of scenarios or circumstances. You can see some different examples of that there. So how do we, this is, I think, what I've just been talking about, right? Going through step 1, step 2, characterizing the effluent, the receiving water, identifying the applicable water quality standard. But then you need to look at the actual volume, the proposed concentration, right? Comparing that to the water quality criterion, the actual concentration or state of the receiving water body. It's not just what we need to maintain it at to meet the designated use, but what is it actually at right now, right? And how much pollution can it actually absorb before that water quality standard is exceeded? So DNR actually has a spreadsheet that I have buried somewhere in our drive, but it has it for different contaminants and different situations. It can plug in past sampling and effluent data in the applicable water quality criterion and actually just spit out what the WIC bill would be, right? So anyway, this is how we get from a water quality standard that is just generally designed to protect, right, the designated uses in receiving water bodies, and how that gets translated into an actual permit limitation, which is almost always a WIC bill, but could manifest sometimes as a T bill based on technology and other things. Sometimes it can be narrative versus numeric. Here, outside of our current presentation, but hopefully Bill will address this here in a couple of months, gets at total maximum daily loads. All right, I'm going to keep trucking here. Here is one issue identified, right, as an element of a permit that has serious ramifications, and I think mostly about whether an entity is ever going to comply with an effluent limitation that applies to them, right? Or at the very least, can extend the date by which an entity will ultimately comply, right, with an effluent limitation. So a compliance schedule is basically something that is available to permittees seeking a reissuance or someone who is trying to obtain a permit for the first time. The idea is that on day one, they don't necessarily need to comply with a water quality standard derived effluent limitation, right? If the water quality standard that applies was established within the preceding 3 years. Particularly for reissue permittees where these standards are becoming or are applying for the first time, right? It can be difficult to comply on day one. For new sources, I have opinions about that, but maybe we won't get into those today. But regardless, right, it does provide a little bit of flexibility to permittees to hopefully, but this really doesn't happen as often as you think it would, right? Achieve compliance with those newer limitations over the life of that next permit term, right? And these compliance schedules can't go past that. So basically, these compliance schedules require a permittee to simply explain the steps they intend to take and the deadlines by which they intend to take those steps over the course of the permit term to achieve compliance. They usually do this through what's called a pollutant minimization plan. And there's all sorts of things, right, that they can identify there. Maybe it's the installation of really expensive treatment technology, in a few years. Rarely the case, but sometimes that could be a step that they intend to take, right? But short of that, a lot of times they'll try to take actions that avoid costly facility upgrades like source reduction measures, things like that. They try to go out, figure out how these contaminants are getting in their waste stream and simply try to get them out of there in the first instance rather than treating them on the back end, right? So there are different ways to get at a PMP, right? But these compliance schedules, I think, are interesting, and they are something, if you're looking at multiple WPDES permits, that you will come across. But if you don't end up achieving, right, that compliance schedule, it doesn't necessarily result in a violation of your permit. I have seen entities, it even says in the code, right, that even upon reissuance, right, that you may be still eligible, even if that 3-year mark is long past. And I have seen instances where people get compliance schedules, which are only supposed to be 5 years and result in compliance, but then get those same schedules over multiple terms. A little bit frustrating. But even then, and I'll talk about this shortly, they can also be eligible for a variance, which, if certain criteria are met, simply mean they don't have to comply with that effluent limitation. But the big thing here is, like I said, it can either extend indefinitely, but certainly protract it significantly, the ultimate timeline for regulated entities achieving water quality standards. So I want to give PFAS as an example. As I mentioned, August 2022, we got surface water standards for PFOA and PFOS. Now, those don't get implemented into all existing WPDES permits immediately. They only get implemented when existing permits are reissued. So it may be a full 5-year cycle for permits that were issued right before August 2022, can be a full 5 years before they even have to think about how they might comply with it, before PFAS is ever mentioned in their permit. At that point, right, there's a question about the extent to which they have to engage in monitoring and stuff like that to know whether or not they even need an effluent limitation, which could be imposed during that permit term, but might not be until the following permit term. We're all the way out to 10 years. And then they get a compliance schedule beyond that, another 5 years, right? So we're at 15 years. And guess what? Even at the end of all that, they can still, in certain instances, get a variance, right, on top of that. So it can be 15 to 20 years before we even hope for full compliance, knowing that there's still going to be outliers, right, who receive variances for that. Okay, speaking about variances, there are two types. Well, before I get into that though, what is this, right? It's ultimately a variance from complying with the water quality standard itself, right? And a variance in and of itself is technically a water quality standard, and there is some EPA oversight here. But it's saying that you do not have to comply with your effluent limitation, and based on your current practices and all of those things, here's your elevated, right, effluent limitation that goes above that water quality based effluent limitation, and would obviously therefore contribute much more significantly to the potential increase violation of a water quality standard. So there's two types of variances: an individual variance, so just that individual permittee can get it, or my old foe, the multi-discharger variance, which I'll discuss on the next slide. As far as individual permits go, both in federal regulations and in state law, there are 6 different criteria that attaining a water quality standard right through the WIC bill is not feasible because of one of 6 different reasons. Now here I've highlighted 3 because those are the 3 that I see most often. You can read them all here, and again, these slides will be available, but one of them is naturally occurring pollutant concentrations prevent the attainment of the standard. A lot of toxic substances, the metals we talk about, those occur naturally in the environment: mercury, arsenic, copper, those things. And certainly the source, water that they're getting and putting through whatever processes that results in wastewater, right? That input there could already be contaminated above the concentration, like in the WIC bill. So that they would need to meet. So the idea is they're not really adding pollution, they're just moving it around, I suppose. And in that instance, if attaining the water quality standard is prevented because of that, you may be able to receive a variance. A second one is human caused conditions or sources of pollution prevent the attainment of the standard and cannot be remedied. Or, and this is the more applicable one that I wanted to talk about, would cause more environmental damage to correct than to leave in place. I've actually seen that second one asserted quite a bit in a chloride context. The idea is that, you know, from all inputs, like through a combined sewer system to a municipality, right, who may be getting quite a bit of water softener salt or even road salt, right, if there is combined storm and sanitary sewer there, that if they can actually remove that from the wastewater stream, but doing so creates a byproduct that they don't have a reasonable means to dispose of, that would actually create worse environmental damage, in their opinion, than simply continuing to discharge it right to the environment. So that can be a justification for a variance as well. The last one, and this is the one I see most often teed up and is most often applied for from more public entities like municipalities operating a wastewater treatment facility, is that the standard as applied to the permittee will cause substantial and widespread adverse social and economic impacts in the area. That's crucial, in the area where the permittee is located. So the idea here is, if a wastewater treatment plant has to install cost prohibitive treatment technologies, right, they are almost assuredly passing those costs off at some point to ratepayers, right? And if the cost to ratepayers become astronomical there, certainly, and especially we can think about this in an EJ context too, right? You may have a diminished ability to pay for increased sewer rates for that, and it can hit some people harder than others. So in certain instances, there very well may be substantial and widespread adverse social and economic impacts. But it has to be in the area. It can't be a business or something like that saying, oh, our factory in some other state's going to lose a bunch of jobs because of that, right? Maybe that's adverse social and economic impacts, not in the area, and doesn't qualify. But anyway, these are the 3 reasons. These are listed in a variance application, and if they're wanting one, they'll check which one they want. Sometimes they'll check a couple, but anyway, there's also a multi-discharger variance. This is sort of like a general permit, but for a variance, right? In that it applies to typically categories or classes, either of dischargers, or in certain instances for the pollutant outright. So phosphorus is something that I specifically didn't work on, but MEA worked on 4 years to get a phosphorus standard in Wisconsin that would help curb some of our nutrient pollution, algal blooms, all of those things, right, that we still see today in Wisconsin. We fought hard for that, got it, only to have a Walker administration led DNR and Trump led EPA push through this multi-discharger variance, saying that the water quality standard for phosphorus will not only create wide adverse socioeconomic impacts for individual permittees, right? Remember this last standard, as applied to the specific permittee. Well, they're saying basically all permittees, right, will be subject to those adverse socioeconomic impacts. I will say, though, built into the law, the threshold determination of those adverse economic impacts is subject to review after 10 years, and we're only 3 years away from that right now. So keep that on your radar. I think it'll be important for folks to weigh in when that time comes. Another multi-discharger variance I'll mention that I really don't like is the one for mercury. The reason I don't like this is simply because despite reviewing this, which is a water quality standard, a variance is a water quality standard. Despite reviewing this every 3 years as part of the triennial review, DNR continues to rely on a study that is now 27 years old and has not updated its determination from 2002 that the mercury standard could also result in those adverse socioeconomic impacts. Whether or not a multi-discharger variance for mercury continues to be justified is a little bit beside the point. I question whether you can continue to justify it on such outdated and stale information. We need to update that and make sure those determinations made over 2 decades ago, based on an even older study, remain accurate. And it needs to assess all the updated information that could apply there. Certainly, there have been all sorts of efforts, particularly from startups and industry, to try to create new technologies that'll be cost effective to get at phosphorus, chloride, mercury, etc. So those are variances. I was just checking the chat real quick to see if anything immediately piqued my interest that I could respond to, but DNR stepped enforcement. So when there is a potential violation, right, of a permit, what does DNR do about it, right? Are they immediately issuing like super expensive fines as a deterrent, right, and taking them to court, right? Almost like you would like traffic violations or something like that. Well, you can pay the bill or you could contest. That is not how this plays out, right, in this context. And typically, it's only if they get to the very end of this process called stepped enforcement, are we starting to see hefty violations, right? Maybe even injunctions and citations and things like that. So stepped enforcement, though, is the idea that you can slowly elevate potential violations, and the stakes get higher and higher as they go, with the idea that not all violations are equal, right? Some may be more benign. It may be, hey, we submitted our sampling data 2 days too late, right? That's a technical violation. But if the sampling data still says, right, they're complying with the effluent limitations, right, maybe that doesn't require us prosecuting that, or DNR, I mean, in court. So you're right, versus just blatant discharging without a permit, right, or exceeding effluent limitations repeatedly and not getting it under control, things like that, right? So this is a spectrum here, and certain enforcement actions may be more appropriate than others. So anyway, you start with an informal contact, information gathering. You might send a notice of non-compliance, hope they figure that out. If they don't, you might come back, DNR as a team, discuss whether additional enforcement is necessary, information gathering, issue an NOV or notice of violation. If it still goes, or after that, you may have an enforcement conference with the relevant parties, not only DNR, but the regulated entity. Try to reach some sort of agreement that may result in an administrative or consent decree that will result in compliance or abating the violation, right? That still doesn't happen. It may ultimately result in a referral to either the Department of Justice in some circumstances, maybe the district attorney, depending on the exact type of violation, or even the Environmental Protection Agency. And at that point, while those entities enjoy prosecutorial discretion and don't necessarily have to go through, that's when we see them litigating things, getting judgments, hefty fines, and injunctions requiring further activity to be taken. And if those aren't fulfilled with, risk of contempt of court potentially. So that's stepped enforcement in a nutshell. But like I say, DNR staff themselves will tell you the goal isn't necessarily to punish, but merely to bring the violator into compliance. In the past, when I found unpermitted discharges, the response was not to escalate that through stepped enforcement because, oh, that may be super egregious. It's no, let's bring them into compliance. Let's have them apply for a permit and then issue that permit, right? And as Bill knows, permit is an action verb. It's a noun. It's not a noun, right? They are permitting the discharge, right? Allowing it to happen. It's not like necessarily the document itself. So anyway, the other thing though that I wanted to talk about here is this concept of a permit shield, because even if the entity may be causing adverse environmental public health impacts, right, based on their discharge, if they are complying with their permit, it can insulate them from government enforcement or something I'll talk about here momentarily, a citizen suit. The other thing is, and other environmental laws actually incorporate having a WPDES permit by reference, and it can also create a permit shield from enforcement in other contexts as well. It's very nuanced and goes to a bunch of laws that we won't get into today, right? There is an open question here on the permit shield, right? Like, what if the permittee says, hey, we have this pollutant in our waste stream, but DNR says, nah, don't worry about it. Sixth Circuit says, if that's the case, then there is a permit shield. If they inform them of it and the entity declined to regulate, then the permit shield exists, right? Other courts have disagreed. I'm thinking Fourth Circuit, and I can't remember exactly where the Seventh Circuit, where we reside, landed on that specifically. I think it may be still an open question. Okay, I know we only have 19 minutes left, so I'll just go through this real quick, as fast as I can. If you want to participate, or even maybe before that, just figure out what permits or activities are being permitted in your community. There are resources for you to figure out where those are, and to find the exact permit, and to read it, and to figure out what the permit conditions are. Do they have a variance? Is there a compliance schedule? So on and so forth, right? So in addition to that, you can also find their actual compliance information with that. Are they violating the terms of their permit? Well, those DMRs, those designated monitoring reports I previously identified, those are submitted to EPA and uploaded to EPA's enforcement and compliance history online there. So that's actually where I would suggest that you start, echo.epa.gov, the acronym there for enforcement and compliance history online. So just real quick, I noticed we had a couple people on here from La Crosse. Oops. So I just wanted to show you, here is the Echo website. Now you can do a very simple search. You can do simply La Crosse, Wisconsin here. However, that will get you all permits across multiple regulatory programs. So air, Clean Water Act, like CERCLA, RCRA, things like that. If you want to search Clean Water Act specifically, you got to go to more options, scroll down here. You see it says CWA, city. Now let's type in La Crosse. Now let's scroll down to Wisconsin, right? And we can see what pops. Now you can do this in two ways. You can get a map, or you can just get a table that brings it back to you, right? And we'll list this kind of in like almost like a spreadsheet. But I think the map is interesting because it just allows you to look at it from a locational perspective. And I'm sorry, the way this browser is formatted here, it may be difficult, but you can go in and click on these different things and it will tell you, oh, look, here is the name of the facility, even right here within the map. What do we see right here? The last 12 quarters, their violation history. Guess what red means? There was a violation, right? So you can click on that specifically, right, and look at a detailed facility report, right? Whoa, what is this? It's the Excel Energy French Island generating plant. This is the trash burner, is it not? Bill, is that what this is over in La Crosse? Very well, maybe, but okay, anyway, so you can find all sorts of information here. In addition to their other reports, you can find characteristics, potential violations, all sorts of things. Okay, now how do you then go find the exact permit? Well, DNR now, it didn't for a long time, but it now has a WPDES permit website here that you can just search. It doesn't have all the advanced options though, like the Echo website, which is why I say you should go there first, because you can kind of figure that out. So what was that? Excel is what it was called. Let's see what pops if we just type Excel as a facility name. Oh, no facilities found there. Northern states, maybe it has to be exact here. What? Here we go. Do you see? You might have to try it a couple ways. Doing business as Excel Energy. Guess what we have right here? We have the permit itself, the actual permit that's scanned. We have the permit fact sheet that gives you all sorts of very quick information about the discharge and the receiving water body. There's a cover letter they put in here and a final determination notice. A lot of times within this, you may also see any variance documentation in here, in addition to some other just general documents. But so this are permits that have already been issued, right? But as April pointed out, you can open that up, see when it'll expire, know when it's supposed to be reissued, and then monitor DNR's WPDES permits on public notice page to see when that facility actually is getting a permit reissued. So these are not all of the permits for which DNR has received a renewal application, but those for which they've issued a notice of a renewal application and are actually proceeding through that permitting process. Here you'll find additional supporting documentation. Each one of these columns, you see how that has an underline right there, right? That's the permit. That's the draft permit right there that you'll want to click on to look at that. That is the public notice, right there, just the date. Fact sheet with supporting documents. It gets you all sorts of additional information about why they may be doing certain things in the permit. Anyway, we really wanted to go through that with you instead of just give you the links real quick, just maybe to set you up for better success. And I did rush through that because I'm trying to get to the end and what I know are the important questions you have. So I'm not going to go through this. This is kind of redundant, but these are the types of things that you can look for in a draft WPDES permit to review. The different types of additional documents, all sorts of things. So this could be helpful for you if you pull an actual permit in your community. I want to talk quickly about getting involved, right? As April pointed out, all individual permits preceded by draft permit, public notice, and a written comment period. They don't all have public hearings. If DNR thinks there's significant interest, they'll order one by themselves. If not, it requires 5 or more persons to petition them to hold a public hearing within 30 days of the public notice, and then they're required to hold one. In addition to that, after a final decision is made, unlike other DNR final decisions, you actually have 60 days to bring administrative challenge to a final decision to grant a permit instead of 30. What is an administrative review? It's kind of a quasi-like trial that is presided over by an administrative law judge. Certainly to do well, any person can just go and litigate that. But again, to do well, you're probably going to need a lawyer, technical experts, things like that to convince the ALJ that you're right and DNR is wrong. So that can be a barrier and things like that. But one thing that's a big issue, and I'll just mention this right here, you can go back and review the note. Just like the public hearing is only available upon request by 5 or more persons, so too is a contested case hearing or these administrative hearings on these decisions. In our view, that violates the Clean Water Act and does not comply with its bare minimums right there. You can go through here and read why, right, in our view, but it creates a barrier to challenging a permit in court that the Clean Water Act simply doesn't provide for. Unfortunately, that's in statute, and we have no appetite in the legislature to amend that. Okay, we're really close. I know it's 5:20. There are significant barriers, though, to even if we have all the laws in place, as a 2016 audit of the WPDES program confirmed, DNR lacks significant resources and staffing necessary to ensure full compliance and implementation with the Clean Water Act. I get the sense from a staff level, they're really doing the best they can and they're stretched just as thin as possible, and that impacts the quality of their work. They simply cannot operate at the level needed without adequate funding and staffing there. It's a real problem, and it persists to this day. We also see entrenched corporate lobbyists who have captured at times the entire DNR, depending on the administration. Certainly have the legislature as currently composed there that can basically just kill any regulation they don't like. In addition to just the rulemaking process itself, trying to keep up with updates to the Clean Water Act, all sorts of barriers there, including RAINS Act. As far as that arduous rulemaking process goes, I will just say one of the most salient recent efforts of DNR to bring its program into compliance with the Clean Water Act is its anti-degradation policy. It is now on the 3rd attempt to get that codified into law since 2009, and it still hasn't been able to get across the finish line. The current proposed rule right now even is on the chopping block. There's also some unhelpful cases about when and where we can challenge certain permits and for what. I'm going to skip through the citizen suit provisions here. This is important, but there are all sorts of potential issues with that. But what I will say is, in Wisconsin, when it comes to just straight up WPDES permitting, not necessarily wetlands or anything like that, this is where the WOTUS definition matters. In order to bring a citizen suit for a violation of like a WPDES permit or something like that, you have to be able to tie it to the Clean Water Act and federal jurisdiction, not necessarily just additional state authority. So citizen suits can be problematic, right, and may not be an entire remedy to get at those things. There's other conditions as well, but I wanted to raise that specifically. There's got to be that federal jurisdictional hook, and there is a little bit of disconnect between state and federal law. And let me just make sure here that there's nothing else I have. I don't think I have anything else. Obviously, this is an overview and an intro. It's way more complicated in that we could have spent 2 hours on anti-degradation, which I just mentioned alone, right? But anyway, I hope this primer was helpful for you, and I'm willing to stay as long as it takes to get the questions answered.
Thank you, Rob. We do have one in the chat, which I'll read off. And then I think we have a small enough group. I'm just going to open up. So in a moment, I'll open it up and you can just unmute yourself and ask questions, because we don't, we only have a handful of people here. I think we can manage that. But Rachel asked, is the factor of adverse socioeconomic impact more likely to be used on waters with certain designated uses over others, such as recreation over drinking water? Do the socioeconomic impacts of allowing a variance have to be analyzed against claims such as jobs lost first in order to get a variance for that reason?
That's a really good question. What I'll say to that is it can matter on the designated uses, right? Say you have a drinking water is a designated use for a receiving water body. That may necessarily, when you're going through and picking which water quality criteria they have to, or criterion they have to comply with, if drinking water is on there, it may ratchet that down where it might not be otherwise. That could create a barrier to compliance, right, with that, and may suggest that they need to install some sort of treatment technology to meet that more rigorous standard, right? So, yeah, it could be, all right, a justification for that, although it will depend on the exact application, the socioeconomic impacts that are alleged, the character of the receiving water body in the community, right? The other part of that is against claims such as jobs lost. A lot of times that claim is made in favor of adverse socioeconomic impacts and in favor of getting a variance. But certainly there could be a situation, right, where not complying with that could create a loss in jobs or something like that. And I do think that information would be relevant. Does DNR have to go out and necessarily find that information? Maybe not. Right. If it's presented to them in the comment period, though, they probably have to take it into account. So is it always weighed? No, but should they weigh it either in for or against the variance, depending on the context? If it's raised, probably so.
The one thing that I'll add to is, and I don't know if this is giving you the information that you're looking for, Rachel, but one of the things that we've seen too is that this argument has led to, and it's particularly in situations where it's wastewater treatment plants that are making the argument to not upgrade their wastewater treatment plants because of the impacts on their customers' rates. And there's can be really significant environmental justice implications where basically in low-income communities, you have polluted wastewater discharges that aren't getting addressed on the argument that that customers can't afford the resulting bills. And there are a number of strategies that utilities can utilize to ensure that people have clean water and affordable wastewater and utility bills. And I'm going to drop a link in the chat to something that's related to your question that kind of just dives into what some of those strategies can be to address affordability and clean water at the same time.
Really appreciate that, April. I want to review that information just so I can improve my own participation in permits. So that's a really great resource to try to rebut some of those justifications, because there are likely many instances, if we tried hard enough, where those two goals aren't mutually exclusive.
Other questions, if you have them, you may unmute yourself and go ahead and ask away. Otherwise, we can kind of wrap things up. I did want to.
Well, one thing, if I could,
yeah, go ahead.
Just not seeing anybody fly off of mute here, Mike, is I did see that we have a couple of attendees from Oneida County who did mention PFAS, right? There, and I hope I kind of addressed that a little bit when I was talking about the groundwater standards and things like that. Anyway, I would invite questions on that particularly, if there are any now.
Eric, Dan, it's your opportunity if you've got a question.
Yeah, this is Eric. I'm kind of in over my head on this nifties and his whipties and all this. I'm just trying to get up to speed. I mean, we do have a serious PFAS problem in Oneida County. I'm hoping Dan understands a lot of this language better than I do. So that's all.
Well,
I really can't comment on a lot of what.
Yeah, what I will say though, right, because I do understand some of those problems up there to be associated with biosolid spreading, potentially not even from a municipality, maybe even from industrial sources there. The reason right now DNR is allowing biosolids to be spread with such high PFAS concentrations is because they can only regulate the impacts to surface water until there is a groundwater standard. Until the legislature gets out of the way of us getting a groundwater standard, we're going to be hard pressed to try to get those biosolid spreadings under control in a way that's adequately protective of groundwater. Eric, this goes for you and Dan, as you think about this more. If y'all want to have a more direct conversation about that, I can try to help unpack that a little bit more for you. Just let me know.
Perfect.
Yeah, Dan, I'm sorry, Rob, I
Oh.
appreciate that. I did include a link. I mean, we did have the county pass a PFAS resolution addressing some of the biosolids. I mean, with the groundwater standards are not going to be set for years yet, right? I mean, until the Natural Resources Board goes through the process again. I mean, I've been emphasizing that to the locals, you know, the issue that you had brought up, that, I mean, this whole the whole now I'm drawing a blank on Wisconsin Manufacturers and Commerce, right? I mean, their lawsuit. I mean, we understand it. And I appreciate this presentation. At least I got my feet wet a little. So I thank you guys for your time.
So if I can just a couple of things, and I know there aren't too many people, and I'll try and be brief, but a couple of these things I just wanted to tie together. One, for example, the lack of DNR resources. That's why citizen folks can be really important, because you can think of yourselves as a way of kind of spreading those resources. You also may have access to information that they don't. In the course of my 35-year career, I have literally gotten blank envelopes that have information about particular facilities saying they haven't told the DNR that we're discharging this stuff, but we are. And so, there is a role to play. This can take a long time. DNR is going to put more effort into places where they know they're being watched. So it's another way that the more the broad aspects of this, you can make it known that you're watching this, and that also can have a beneficial effect. And then the last thing that I'll say, it was mentioned by one of my colleagues earlier, but trust me, we understand how overwhelming in one way this can be. The other thing that you should take away from all of these webinars is all 4 of our organizations are resources. We might not be able to do everything for you, but we can certainly point you in the right direction. We can explain things. We can lay out the strategies, things like that. So anyway, just wanted to throw that in at the end.
Thanks. I'll follow up with Eric. You give me more credit than I deserve on understanding all of this language. But when it comes to the issue of PFAS in Oneida County, and I don't live in Oneida County, I'm treasurer of a lake district in Oneida County, so I live down in Waunakee, just north of Madison. But my curiosity is, with the sludge spreading that has taken place, reportedly in Stella to cause issues with the groundwater. A lot of our lakes up north are groundwater sourced. And there are a number of lakes that around the area there that have PFAS now have been tested and have PFAS in the lake water. So now it's a surface water issue. It's not just groundwater, but it's surface water. I find it difficult to understand how those two cannot be tied together in those certain situations, where, okay, yes, we know that wells are contaminated at 2,000 times the, limit allowed for consumption or whatever the number is. But now we have, but there's not much we can do because we don't have those standards for groundwater. But we do have them for surface water, and the lakes associated with that groundwater are contaminated. So, they kind of go hand in hand. How do you resolve that, or can you resolve that?
Well, it's difficult, right? It's almost like a variation on the county of Maui case from a few years ago, where we have a discharge to surface water via groundwater. Now there, that connection was really close, right? Not quite as diffuse as just like a general groundwater, aquifer that feeds a lake or something like that. And so we'd have to think through that. But there's a public trust argument to be made there for impacts to surface water, right? And all of those things. But I think the difficulty there is in tying it back to particular sources who are spreading on what fields, right? And how do we actually translate that all the way back into an effluent limitation or nutrient management plans for field spreading and things like that to protect that surface water? It becomes more difficult. So the best solution there in my mind is just the groundwater standard, and let's get that out of the way and do both. But certainly in the absence of one, Dan, it's a great question, one that I'm grappling with all the time.
Well, and the other answer to that question, which is not satisfying, but it's just the unfortunate state of things, is you have to remember that at both the state and the federal level, all of our administrative law has evolved. It was not designed. So, you've got a Clean Air Act, you've got a Clean Water Act, a Safe Drinking Water Act, a hazardous waste law, and things like that. And they came about when specific problems were being addressed, but it is also part of the answer to your question, which is they don't look at the world as it exists necessarily. And so you can run into these sorts of problems. And that's something that all four of our organizations try and deal with all the time. So that's the other kind of part of this, is you can get stuff that essentially is falling through a crack.
All
Dan,
right.
not tonight, but at some point, I would love to interface with you and maybe look at that question in an Oneida County specific context. Okay, what are the exact lakes, right? What are their proximity? What's groundwater flow in the area? And what do we know about historical land spreading, right? I think it's at the very least a good thought exercise, and at best could lead to a positive development.
Well, I'd certainly love to do that, but Eric obviously, I mean, lives in the area. Eric and I know each other, so I mean, I think he could also bring, a certain perspective to that, and help identify, a little bit more particulars in that discussion. So, but yeah, I would enjoy that.
Eric, you should have my email.
I have your email. We need some help up here, and I'm just trying to figure out where where it's going to come, where it's coming from, and how best. I mean, we could use somebody up here to speak to the people with with a little more depth on the legal issues. I think lawsuits are flying up here, and everybody's keeping quiet, and lawyers keep telling them, don't say anything, you don't want to affect your case or whatever. Makes it difficult. But as Dan was stating, that same surface water problem that he was stating, the Snowden Lake, which is in Stella, has the worst, absolutely worst level of PFAS, and that is a groundwater. That water from that lake is groundwater fed. The other ones around are testing not good, not acceptable, but much lower than Snowden. So, and that was provided from the DNR, that because of the groundwater source is why they're suspecting Snowden is much worse than the other ones.
Thanks,
We'll
Eric and
talk.
Dan.
Perfect. Yeah. All right. I think I'm going to stop the recording. Before I do, I just wanted to mention that I put in the chat the websites for all of our organizations, how to register. I'd just like to point out that you can join us on Valentine's Day afternoon before going out for Valentine's, or not, depending on how you are. But Adam is actually works with Rob Lee. He doesn't work for the Midwest Environmental Advocates, Midwest Environmental Advocates, West Environmental Advocates, which is the winner for the worst typo I've ever made in a PowerPoint presentation.
I thought Adam quit and I didn't know it.
Don't know how that happened, but if you make that into an acronym, it would fit within the kinds of acronyms that you see in water quality law, I think. So with that, thank you all for joining us. If people want to hang on, that's fine, but I will stop the recording, and we'll talk to you all in February.